Good morning. This is actually a continuation of our sitting today as we started on Zoom. My name is Vicki Henry. I'm your panel chief today, and I'm delighted to be joined by Justice Shin on my right and Justice Toone on my left. We have 5 more cases on today, so we'll probably hear 3, take a short break, and hear the remaining 2. In the appeals court, you have 15 minutes per side, no rebuttal, I did not say my pronouns are she, her. You're welcome to share yours or not as you see fit. And the next case is 2025P 643. It's Commonwealth versus ABDO. I also want to mention we have your materials on our iPads here, so if you see us glancing to the side, that's what we're looking at. With that, we'll hear from Attorney Riley.
Good morning, and may it please the court, Stephen Riley for appellant HAMZAV ABDO. This is my first appellate argument. Your Honors, there are 2 issues in the brief, both of which merit your attention. I'll rest on the voir dire issue unless the court has questions about it. I'll focus on the heart of the ineffective assistance claim, the failure to request the lost or destroyed exculpatory evidence instruction. As an initial matter, when a defendant asserts that exculpatory evidence was not provided, he or she must make a basic showing that the evidence existed. Here, the testifying officer, Officer Campobasso of the Nahant Police Department, testified twice that there were cameras in the booking area at the station. He also testified that the booking video was not provided for Mr. Abdo, an inference that there was in a recording. The prosecutor in this case did not clarify or challenge that testimony on redirect, although he had every incentive to.
So the Commonwealth seems to argue that really this should have been made as a motion for a new trial, so we had actual facts here as opposed to inferences. And they basically argue that it appears the cameras were used only for live surveillance, at least based on the record we have before us, not for recording. What do you say to that?
Well, I say, first of all, there is no evidence in the record these are live surveillance. And as an aside, booking video evidence is very standard in courts of the Commonwealth and every jurisdiction, every day, every week in the Commonwealth. So if Nahant Police Station uses a nanny cam, which is effectively what live surveillance is, the prosecutor on redirect would have probably had every incentive at that point to say, the video was not provided, isn't that because there's only live surveillance at the police station? So the witness's answers make it clear, and I think the most reasonable inferences that can be drawn from him are that he says twice there are cameras, it's not audio recorded, but there are cameras because that's where the holding cells are, and when asked, was any of that booking video provided to Mr. Abdo, Officer Campobasso says simply and directly, no, it wasn't. So I think the answers here make it clear that there's the factual basis of this claim is indisputably on the trial record for purposes of appeal.
Well, defense counsel said that he or she says it's unclear whether there was video, right? And during the discussion with the judge, he says it's unclear whether there was video.
Correct, Your Honor. I'm not sure that don't want to parse words here, but he does faintly say that it's not clear when he's making his request for an omissions in police investigations instruction. But he does make clear his 2 objections, which are there was no audio video provided, and then, as I say, not his strongest argument, but he does say, you know, if there was video, and it seems like there could have been video or there was video based on the witness, I'm paraphrasing, the video should have been provided and it wasn't, and then went ahead and requested the instruction. So I'll concede, of course, as I must, that the transcript does suggest that trial counsel was a bit faint on making that argument, but the witness's testimony, nevertheless, I think establishes that there was video And that this is part of the problem with trial counsel's performance. But I think the testimony establishes that fact. And I think that, in its brief, the Commonwealth has adopted a much broader and more definite position than the unserved position of the prosecutor. Because later in the trial, when he's asking for the omissions in police instruction, the judge says, hey, wait a minute. So turns to the prosecutor and says, is there any video in this case? And the prosecutor answers, not to the best of my knowledge. In other words, I don't know. And here, the Commonwealth has taken, in its brief, a more definite position. It now claims to know that the booking video did not exist and is asserting that it's imaginary evidence. And because this is such a critical fact, and because this court is in an excellent position to determine this fact on this record, I think the issue is properly before this court.
So I don't think the Commonwealth is arguing that, as a matter of fact, the video doesn't exist, but rather we can't tell on this record whether it exists because the officer's testimony can be read as saying that there were cameras, but not necessarily a recording. So why shouldn't this claim be brought in the context of a motion for new trial?
Because I think Officer Campobasso's answer, when asked, and I can refer the court to the transcript on page 96, if it so wishes, that he asked him, and there was no booking area video provided of Mr. ABDO. No, there wasn't. I mean, there aren't too many other ways to answer that question other than, no, there wasn't, because we have live surveillance. I mean, he did demonstrate, Officer Campobasso, that he had a functional knowledge of the recording systems in the station. That is, he knew it wasn't audio recorded. So he seemed to have some understanding. It's a small police station. I think it's every officer on deck with lots of duties and responsibilities there. It's not like Boston Police Department, which is a sprawling, large metropolitan complex. So he demonstrated knowledge of the system, of the recording system. So I think his answer can be taken, as it is. No, it wasn't provided to him. I think that this court can take that answer as evidence that there was a recording that was not turned over.
And how do we know that the video, if there was a video, would have been exculpatory?
So the subjective recollections of Officer Campobasso as compared to the objective recordings, anytime you have a subjective recollection, objective tape, there's going to be discrepancies. And so the potential is inherent that there will be exculpatory evidence. And here, Officer Campobasso's testimony at the stop and the field sobriety test, his testimony about Mr. ABDO's demeanor and his behavior and his performance on the field sobriety tests is quite different than his testimony about how Mr. ABDO behaved during the booking. That is, at the stop, he was cooperative, he didn't resist, he got out of his car without staggering or stumbling across the street, waited for instructions about how to conduct the tests, was very observant to the officer's commands, and did reasonably well. The impairment evidence is extremely thin on the field. Nevertheless, he was arrested, was very cooperative, got in the car, no problems. 10 minutes later, in the booking room at the Hot Police Station, he's mostly argumentative. He's arguing and studying so much, he can't be understood by Officer Campobasso. He's throwing a phone at the officers, and he's swaying or is demonstrating a lack of balance and coordination. So the impairment evidence at the booking is, the jury could have dismissed all the field sobriety evidence, as they were instructed they could do by the judge, that the opinion of the officer, you can take it or leave it. They could have found him sufficient evidence for guilt just based on the booking testimony by Officer Campobasso. So I think, that the video could have easily shown that Mr. ABDO didn't throw a phone, wasn't argumentative. In other words, his behavior was
But
consistent with officer.
It might have contradicted the officer's testimony is what you're saying, right? But
Yes.
you're kind of, that's a possible outcome, right? But is that all that's required to establish an ineffective assistance claim at this point? The possibility that,
Well, for the ineffective assistance claim, yes, because trial counsel argued this issue, elicited testimony that the video existed, there was a recording that wasn't turned over. He discussed the issue with the judge when he was requesting the omissions in police investigations instruction. He then argued the issue to the jury in closing. I don't have this video. You know, how do we know what the argument was about? How do we even know he was intoxicated, et cetera? So, and that case is this case is very similar to the Cimarrano case that I put in my briefly, which is a home invasion case and a permission to enter defense, where trial counsel had argued, you know, consent to enter, permission to enter. There was sufficient evidence that the appeals court found that the trial judge could have given an instruction for permission to enter on the trial record alone, on the testimony alone. Trial counsel in that case also argued it in closing, but didn't request the instruction. The appeals court, rather than holding the trial judge for not giving a sua sponte instruction, decided to evaluate that case through the rubric of ineffective assistance and found that ineffective assistance on the trial record alone, because trial counsel had identified the evidence, elicited evidence, made the argument to the jury for permission to enter defense, but didn't ask for the instruction. And here, it's effectively the same thing, except he asked for the wrong instruction. So as a practical matter, there's no different. The prejudicial impact is the same on the defendant. So as to the test that was given for the underlying, to get to the instruction, the video existed, was not turned over, explained, and there were a lot of constitutional mandatory discovery and professional rules of responsibility that require the Commonwealth to turn over evidence, to discover it, preserve it, inquire, investigate. There's a whole passel of duties. Here, the prosecutor's answer, when asked, I don't know, is really proof that all those duties were violated. And there are corresponding constitutional rights when those duties are violated. That is, it infringes on a defendant's right to present a defense, a right to impeachment, a right for the jury to hear all the evidence, a right to a fair trial. I mean, when these duties are violated, and they were in this case, the impact on the defendant is clear here. And that counsel identified the issue, argued it to the jury, and didn't ask for the proper instruction, only points that out. He was entitled to the instruction in the absence of the booking video, and it was really the only remedy available to him. And trial counsel failed to request it. This case is Heath, essentially. I mean, boiled down, it is Heath. In Heath, there was a booking, a testimony of a police officer about the booking, assault and battery on a police officer, and that testimony was evidence of a crime, but no booking video was provided. Same scenario here. Officer Campobasso testifies about a booking. It's evidence of a crime, OUI impairment. As I said,
but the Commonwealth says the video could have shown anything. It could have, in fact, corroborated the officer's testimony. So what do you say to that?
I say the record suggests that, that Officer Campobasso's own testimony about what happened at the stop and the field sobriety test suggests that the video could have very easily agreed with that characterization of Mr. ABDO's level of intoxication or his impairment. The impairment evidence at the stop, again, was very, very weak. It's a very weak case, unless you look at the booking video, behavior that's testified to. So I would say that there's evidence in the record that shows that the video.
He admitted to having, I think, 2 beers of a particular brand, and then in the car, he had an open container of a 16-ounce can of beer that was a different brand,
Correct.
half drunk, and then 6 empty nip bottles, all in the car.
Correct. There's no evidence that he drank any of those, had drank any of those 6 nips. And Officer Campobasso did his job. He asked him to take a field sobriety test. Mr. ABDO listened carefully to the instructions, and, the transcript shows that he, the Craig case that the Commonwealth cites in its addendum, for reasons that aren't clear to me, but if you look at the impairment evidence in Craig, where the defendant is staggering, slurring, unable to walk a straight line, unable to follow instructions, that's classic OUI impairment evidence. If you compare all those specifics to Mr. ABDO at his stop, he's not slurring, he's stuttering. Unfortunately, trial counsel didn't raise that. Stuttering is not evidence of impairment in the Commonwealth. It's either a speech impediment or, as I argue in my brief in a footnote, it could have been disfluency. So.
All right, your time has expired, so I think that absent any questions, we'll have to leave it there, and we'll hear from Attorney Padalano for the Commonwealth.
Thank you, Your Honors.
Good morning, Your Honors. ADA Matthew Padalano on behalf of the Commonwealth. Your Honors, I'll start with the instruction issue, given that that was the bulk of the defendant's time spent. So in this case, we do not have the kind of concrete evidence that is required to handle this issue on direct appeal. At most, we have inferences and conjectures as to whether or not the video evidence even existed. And I just want to briefly turn the court's attention to the statements made that are relied upon in that booking area that is not audio video recorded, correct? I believe, I'm not 100% positive, there are cameras, it is not audio recorded, but there are cameras there because that's where our holding cells are. And that's trial transcript, page 96. So what that establishes, right, we are in a world where we are required to have concrete evidence. And that is only concrete evidence that there is cameras. If anything, that suggests that the officer believes that there is no recording. It certainly, is concrete evidence that there's no audio recording, and it suggests that he does not believe that there is audio-video recording, because that's exactly what he was asked.
Can I ask, this may be off topic, but in a case like this where the defendant's conduct during the booking process is significant to the case, if there is a video, is that something that the Commonwealth should produce?
Certainly. So I think it's the standard practice to produce it. I think my understanding of the general practice is that the prosecutor asks the police department, if there's any video, please turn it over to us so that we can turn it over to the defense counsel. And again, that's what the prosecutor elicited, right? He was asked, is there any camera, any video in this? And he said, not to the best of my knowledge, because he only has his own personal knowledge and the knowledge of the Commonwealth generally.
That seems a little weak. He should say, I asked the police department, they told me no such video exists, right? He could make that representation, but just sort of say, the best of my knowledge, it does kind of raise the question, did he really make a thorough request and ascertain whether this video existed?
Sure.
And that ambiguity has sort of caused some problems for your position.
And I think, unfortunately, we are stuck with ambiguity because we're in a direct appeal world. And I think
Well, are we? I mean, if the moment this appeal comes through, if you knew there was video, would you just brief this appeal and just see what happens? Or would you deal with the fact that it wasn't turned over and maybe we wouldn't be here right now?
So if I had access to this video that existed or knowledge that this video existed, I think we'd be in a very different world. But to the best of my knowledge, this video does not exist. That being said, again, I am relying on representations of other parties, and so I am in the position of saying, to the best of my knowledge. That is unfortunately the best representation I can give this court.
So say it goes back, say there's a motion for new trial and it turns out there was a video, then would, in that case, the defendant have a valid ineffective assistance claim?
They would have certainly a much better argument. I can't posit whether or not they would be successful in that argument, given, in that case, we'd have to know what did the video show, what would the video have shown, and I think we'd likely have potentially testimony of other officers who may have witnessed the behavior during it and, could say whether or not the video would have shown what they said. But in this situation where we're dealing with only trial testimony, we are stuck with guessing and inferences as to what it may or may not have shown.
If there were a video, there might be a potential Brady issue to raise in a motion for a new trial, or if there were a video that wasn't produced, you would agree, right? That would there would be different avenues for relief in that case.
Yes, and I think, the Heath case is a good example of maybe the mechanism that could have been done in this case, right? There could have been a motion to preserve the evidence. There could have been litigation about, having that video come forward. And in this case, we just simply don't have that because it wasn't an issue. And that would be a subject of its own, motion for new trial potentially. But here where we're dealing with a direct appeal, the defendant is required to show concrete evidence, not only that the evidence existed, but that it was exculpatory. And maybe this testimony from the officer could be, lead to an inference at best that the video existed. It certainly does not provide an inference that the video was exculpatory. There's nothing other than the video existed and it would have shown something that suggests that it would have been exculpatory evidence. And the case law is pretty clear that that is simply not enough, that you have to show through concrete evidence, and that phrasing is very particular, that the evidence would have been exculpatory. If the court has no further questions on that issue, I'd turn to the jury rehabilitation issue. So I think in this case, the court needs to look very carefully at what was the affirmative answers given. I know it's tempting to turn to the last answer given as the only affirmative answers given by the jury, but throughout the judge's colloquy, especially particularly jury one, he says right, and he's giving sort of affirmative answers to understanding the question. And so each of those answers is an affirmative answer. And there's plenty of case law that says, yes, I think so, would be able to do the best, did not think, no, I don't think so. All of those are acceptable because it's the judge and the trial court that has the best ability to determine the credibility of these answers. And if they are affirmative answers, if they're equivocal, if they're still, shaky about it. And I think Juror 7's colloquy shows that the judge didn't simply take a yes and move on and go to the next juror. He got a yes, and then he said, do you have any other concerns? And then when there was another concern, he continues to probe into whether or not this juror was biased. And again, the standard for this is a clear showing of an abuse of discretion or that it was clearly erroneous. Here, I think the answers are wishy-washy at best, and so the trial judge was in the best position to determine whether or not those affirmative answers were unequivocal answers of impartiality. And here, I believe they were.
Do you agree the objection that was lodged to Juror 1 was enough to preserve the issue?
Yes, I believe both the Juror 1 and Juror 7, the issue is preserved. I think the fundamental issue comes down to whether or not the answer was an equivocal or unequivocal answer. And I think where the answers are right, yeah, so yeah. I understand that sometimes these words get muddled in the transcript, goes from common speech to written word. Sometimes these get muddled. And again, that's part of why it's best for the trial court, who's in the best position to read the demeanor of these jurors to determine these issues. If the court has no further questions, I would rest on my brief and ask the court to affirm the defendant's convictions.
Thank you very much. We understand your arguments, and the case is submitted. Our next case on today is 2024 P1468, Commonwealth versus Del Valle Rodriguez. And I believe we'll hear from Attorney Weber first.
Good morning. Philip Weber, representing Mr. Del Valle Rodriguez. Mr. Rodriguez's case is here today as the motion for required finding should have been granted specifically in regards to the kidnapping charge in this case.
So could I just ask a housekeeping question that's actually quite important, which is, are you challenging all three kidnapping charges or just the kidnapping charge involving Nicholas Carnevale?
All three of them, Your Honor.
Okay.
And I apologize if I did not make that as clear as it should have been in my writings. As ultimately the argument would apply the same as to all individuals that were involved in regards to this. Because, as Your Honors are aware, for kidnapping would require the intent to kind of confine the victim. And there was no intent here in that regards. Now, obviously, there were criminal activities that took place, as I'm not stating otherwise. There was certainly an intent to attack these people, which did unfortunately take place. But an attack alone, obviously, does not automatically mean kidnapping. The level in which the victims were constrained wasn't because of Mr. Del Valle Rodriguez, it was because of, well, bad luck, essentially. It was the car getting stuck in the mud, which no one actually did. It's not as though that was set up or anything.
I think, well, there are many things the Commonwealth did argue. I guess one argument would be that once you realize you're stuck in the mud, you'll get out of the vehicle and try to push it out of the mud, and that here, they couldn't get out of the vehicle when they might have otherwise wanted to. So what do you say to that?
Well, I mean, getting out of the vehicle resulted in, I mean, obviously getting out of the vehicle leads to an interaction with the individuals here, the defendant and otherwise. So that did lead to the interaction which happened, which led to the other criminal actions, which is not an issue, which is not being challenged today. So that certainly happened. It's not that they could not get out of the vehicle. No one was, in fact, quite the opposite. It's not that they were preventing them from getting out of the vehicle, quite the opposite. The defendant and other individuals wanted them to get out of the vehicle. So there was nothing actually preventing them in regards to confining them getting out of the vehicle.
Well, they were, the defendant and the other men were beating on the truck. They were threatening to harm the people inside. And so even though they wanted them out of the truck so they could assault them, isn't a reasonable inference that the victims might well have felt like their best option was to stay within the truck, and that was the best hope for their safety. And so in effect, through the defendant's actions, they were confined in the truck?
I would argue I'm sure the victims felt fear. I mean, they probably were scared in that situation and weren't sure what would be the way to go, where they would want to go. But feeling fear and maybe wanting to try to escape from a perpetrator in and of itself, I would say, does not amount to kidnapping. Just because a person wants to go, the idea that they would want to run off in some direction, but they have these people who are trying to physically harm them, that in of itself, I would argue, is not amounting to kidnapping. I mean, they were threatening them. If there had been a charge for threatening, certainly would have been a possible charge. Because again, it's not a quick statement that there was no criminal activity. Obviously, in a situation like this, and to the facts as they amounted, it would be, I think, essentially impossible to argue there were no criminal activity. But the difference between whether there was criminal activity and the type of criminal activity is the question here today. And I would argue that what happened didn't amount to kidnapping, because it's to constrain someone just through the idea of, well, I'm scared if I get out, there will be a fight, is, I would argue, not in and of itself kidnapping, especially since, the idea that they would, because as Your Honor stated, if no one else had been there, if they had just been caught in the mud without anything else, their action would have been to get out of the car and try to free themselves from the mud. That's what the defendant wanted for them to get out of the car. Because that's the thing, the defendant would have wanted them to get out of the car. So the idea that, well, they can't get out of the car because the defendant and others were there, I would argue goes counter to what the defendant's intent was. Because the defendant's intent wasn't to keep them in the car. Literally the opposite. Wanted them out of the car. The yelling is about wanting them out of the car. So the thing that they would...
The Commonwealth, though, is going to focus on the restraint of movement, and that he was restrained from moving out of the car to free themselves from the mud.
Well, they were not actually, and I would argue that they weren't restrained from moving out of the car. They were, I'm sure, scared to get out of the car. I mean, and I would argue that in any circumstance in which there is violence, in any circumstance in which there's, criminal activity of a violent sort, there's going to be, a level of fear and concern from a victim in terms of, what will happen if I do a certain action. But just the sheer idea of fear alone would not constitute kidnapping, especially when the fear here is to do the thing that the defendant wants them to do. Because again, it's everything they want to do is the defendant didn't want these individuals just.
Do you agree with the Commonwealth that specific intent isn't required?
I would argue, the problem here, I would argue, is that there would need to be, I think there would need to be some kind of intent to confine the victim. And that intent, I would argue, is not present here. So the idea of
But that is specific intent. You're saying there has to be a specific intent to confine or imprison the victim, right? But it seems like that's not what the case law says. The case law says you have to show specific intent as to the third prong of the kidnapping charge, but not as to the first or second, and then you just have a general intent requirement for those two. Am I reading that wrong?
Well, it's not so much as that Your Honor's reading the prongs. Obviously, Your Honor's, quite aware of the prongs of the, actually, it's more so that the intent of the defendant here wasn't about confinement in any way. The intent here was to attack these people. That's the intent, is to attack these people. And in the same way that if someone is behind a closed door and someone tries to break down a door to get to somebody, if a defendant breaks down a door to try to get somebody so they can attack them, they didn't kidnap them by breaking down a door, even though the intent there is to gain access to the person. Because that's the thing, the ultimate intent here was to attack them. You have to gain access to them. You can't attack someone if you're not within physical reach of them, of course. So the intent here was to gain that physical access to them so that they could attack them, which certainly leads us to all the other offenses.
A general intent analysis was, did the defendant act intentionally in a way that violated the statute? And that would be forcibly or secretly confining or imprisoning another person, right? And so you're trying, I think it seems like you're just kind of trying to sort of say, though there's more here, there actually has to be some kind of intent to confine, as opposed to intentionally acting in a way that violates the statute. And I guess, is there a different way to look at this issue than you resting on a specific intent argument? Because I don't think you're going to prevail on that, given where the case law is. But is there some other way to look at this from a general intent perspective that supports your argument?
Well, even from a general intent perspective, I would argue that even if we're not talking in regards to confinement, there would need to be some kind of general intent to kind of limit the movement of the victim involved. And ultimately, the intent we have here is just to harm. It's an intent to attack, to harm, but there was never any kind of intent to limit their movement in any kind of way. The intent here was, again, just simply to gain access to them. That's why I made the analogy to breaking down a door, or even if it was, even if the intent was, even if someone was running after someone. I mean, if two people were in an open field and a defendant was running after someone to try to attack them, then I don't think we would be reasonable in saying, well, this victim wouldn't feel comfortable staying still, because if they just stayed still, they would, because of what was happening. I mean, any kind of action in which one person attacks another is going to cause a victim to feel some type of feelings in regards to whether they can stay still or try to flee. I mean, that's fight or flight is essentially, and in this regard, the flight part is always something that comes into play when you have one person attacking another. So there's always an element in which a victim will feel like, okay, can I stay still or do I need to go somewhere else? That's true in any type of violent act.
Not every type of violent act has the confinement aspect too, right? And here, unfortunately for your client, there was like the confinement in the truck thing that is a wrinkle to. I totally see your point. Like, this is a very natural aspect of assaults, but here, the wrinkle is they were for some period of time effectively confined within the truck.
Well, the period, and I would argue the period that they were confined within the truck, and again, as I stated, the car being stuck in the mud, bad luck, not about any person, just, rain. It rained, it was muddy, the car got stuck. No one did that. So it's not as though they were stuck inside of a truck because of something the defendant did. If the mud's not there, they hit the gas, they drive off, the end. We only have that because of that. And then at that point, nothing that the defendant did actually forced them to stay inside of the truck. I mean, staying inside of the truck, maybe someone breaks the window and gets in. I mean, we didn't get to that point, so we don't know. But none of the defendant's actions would have actually kept them inside of the vehicle. In fact, it seems, as Your Honor was pointing out, they probably at that moment, well, whether they would have preferred to stay inside the vehicle or not, we can't say for certain. We didn't get any direct testimony about what they wanted in that moment. But the defendant certainly wasn't keeping them inside the vehicle. The defendant wanted them to get out of the vehicle, and that's about gaining access to a victim. And if gaining access to a victim, actions taken to gain access to a victim, were to constitute kidnapping, then I would argue that just about any kind of criminal activity in which a person is gaining access to a victim would suddenly constitute kidnapping. Because if we'd applied it to this case, and kind of the crux of my argument here is that if an act about gaining access to someone means that it's kidnapping, when does it not apply? The actions here were to gain access to the victims. That's what the idea was. That's what the actions of the defendant were. And certainly, those actions constitute types of criminal activity. It's not as though what the defendant did is just allowable. There's certainly no argument in regards to that. Even if your honors were to agree with my argument, there are still criminal convictions that would stand. So this is not about everything going away. It's specifically in regards to the kidnapping, because ultimately the actions of the defendant and the others involved were to gain access to the victim for the purposes, certainly, of attacking them. That was why they wanted to gain access to them. So they didn't perform any actions that kept them in the car by any means. And even in regards to them getting out, I mean, they were attacking the car to get to these people. By doing so, it leads to the charge we have, but I would argue that the kidnapping charge was a step too far, essentially. That was the charge and resulting fiction that should not have been in place here, because whether we look at it in regards to a general intent, specific intent, the intent really was to attack them. There was no intent to do anything beyond that.
So the Commonwealth argues that your reliance on Commonwealth versus Morrison is misplaced because in that case, the person was charged as an accessory before the fact. What do you say to that?
And I apologize that I don't have that cite right in front of me in regards to that, but regardless, I would argue that the arguments that I make, whether or not you charge someone as an accessory or as a primary, ultimately that is not what this case was hinging upon. This case, I would argue, is hinging upon, at least in arguments about what the idea was, what the intent of the defendant was. So I would argue that that distinction would not be controlling in this case in regards to the ultimate outcome. And unless there are any further questions, I would rest on my brief.
Thank you very much. We'll hear from the Commonwealth. Attorney Swan.
Good morning, Your Honors. May it please the Court. Sarah Swan for the Commonwealth. First of all, there is no question that only general intent is required. I would agree with you, Justice Toone, that the defendant would not prevail on a specific intent belief. With general intent, I believe Commonwealth v. Saylor sort of explains what's going on, what's required. This court explained that the Commonwealth did not need to prove that the defendant harbored a specific intent to confine a victim. Merely the fact that the defendant had confined the victim was sufficient. That is all that is required for general intent.
What is, could you just give me a little bit more? What is the general intent here that's relevant to the kidnapping charges? What exactly is the intention of the defendant in that regard?
Well, for general intent, it is just that you would intend to conduct the criminal conduct. So here that is the participating in the aggressive attack on the truck. That alone is sufficient. It's a mob attack to prevent the people inside that vehicle from moving, and that therefore is connected to the confinement and their restraint of their movement.
Well, but let's make it a simpler case that they jumped into a vehicle that had no engine in it, so that everybody knew there was no chance the vehicle was going to move. And it is as your opponent argues, they wanted him out of the vehicle. They didn't want him in the vehicle. They wanted to beat him up or shoot him. So where's the intent to do anything to confine him?
What the intent to want them to come out for another purpose is really irrelevant to the analysis. General intent just requires that the defendant do the conduct, which is to effectively restrain the victim's movements. So,
but weren't their movements already constrained while the defendant was still walking towards the situation?
So as the defendant's walking toward the situation, his close friend, who he had been in contact with while at the party, was there already, and he was going to join them, and in fact did join them in banging on that truck and not allowing the people to get out or at the time or at that moment or leave. And then at some point, the restraint sort of transitions to get out or we'll start shooting. And they used the co-defendant who used that language said we, which the Commonwealth argues includes this defendant, which then in fact happened. The defendant did utilize the 9mm gun that he was in possession of and shot the victim.
Right, so I am trying to understand the outer limits of this. So on the one hand, a hypothetical, somebody is starting to break into somebody's house and they have a panic room and they run in the panic room and lock themselves in. Is that kidnapping?
They run into a panic room.
Or a locked bedroom, or,
I would argue it is, Your Honor. We have an unpublished decision, Commonwealth v. Parker, where it was found that the victim was confined into her own home for over an hour by the defendant throwing weapons and destroying furniture. So I think if your movement, even if your own property is constrained for any amount of time that you feel unable to move, that can constitute kidnapping.
Really an expansive view of it's not, we all have a sense of what kidnapping is in real life, and but using this to say anytime there's kind of assaultive or threatening behavior and the victim is in some kind of space that he or she doesn't feel able to leave for a moment, then that's kidnapping, right? Which seems to go against the typical understanding of
Sure. I mean,
affirmatively taking putting someone in a space and keeping them there as a goal, right? And I understand that gets to the specific intent thing, but just intuitively, it seems a little bit off from what we think kidnapping is.
yeah, I think there is sort of like maybe a colloquial, like a almost TV understanding of what kidnapping might be. But in the Commonwealth, we have a definition that is confinement is broadly interpreted to mean restraint of a person's movement. And in fact, that restraint can be very brief. In Commonwealth v. Lent, the victim was restrained by having a gun pointed at her and told that the defendant would use it. And then being pulled by her backpack was sufficient for a brief time until another crime occurred.
So if somebody has somebody else in a headlock and drags them across a parking lot 10 feet, is that kidnapping?
It's possible, yes. The Commonwealth would say yes. I also do want to point out that my brother said that fear doesn't factor in or has no bearing, but the Commonwealth would argue that fear absolutely is considered for purposes of confinement. In those cases I just cited, Commonwealth v. Lent and Parker, the victim's fear was a factor. The threat of potential force is part of a kidnapping. It doesn't actually have to be actual force, which, like in this case, there was both a threat of force of shooting and then also the attack with wooden pallets and sticks by many people on the truck.
In Justice Henry's hypothetical about the panic room, so let's say the defendant goes into the house to commit or to rob the place. Why wouldn't there be merger?
I think there could be merger. It's factually dependent on what happens. They come in and that person is directed to another location or is running in fear to another location and can't escape, whether it's there's people outside the panic room or somebody's outside with a...
But if the defendant doesn't do anything other than enter the house for the purpose of robbing it and the homeowner runs into the panic room, wouldn't that be merger?
I think that likely would be. I think if that's the sole conduct that happens, yeah.
So after every major sports team's victory here in the Commonwealth, people stream down to Government Center and rush over to Faneuil Hall, and if somebody's driving through there, they're going to be confined to their car while the revelry goes on and people are shaking their car and they cannot advance forward even at a green light. Are all of those people committing kidnapping?
No, they're not.
Because?
Because they're,
Tell you right now, that happens every single time there's a
believe you.
championship.
I believe you, indeed. That would not constitute kidnapping because there's no threat of force. It's forcibly confining
They're
someone.
shaking the car.
Well then, I think we would then have to really consider the experience of that victim or the person in that vehicle. Did it reach the point where that person, if they wanted to get out of the vehicle, could they have gotten out? Were they actually being so surrounded that at that
Maybe
point?
they just wanted to drive on and go home.
I think there's a question there of what's going. I think we then get back to we have general intent, and that is, I think, where it's the intent to forcibly confine. That's the act. The act is to forcibly confine a person. So the question would then revolve around that. If the court does not have any further questions, the Commonwealth would rest on its brief.
Seeing none, the case is submitted. We understand your arguments.
Thank you.
I'm going to call the next case, which is 2024 P1297, Carmine Fossile, individually and as a shareholder of Fossile Construction, Inc., and as a member of MCN Realty, LLC versus Neal Fossile, or Fossile individually, and as an officer of Fossile Construction, Inc., and as a member of MCN Realty, LLC. So if I mispronounced any names, I apologize. And with that, I think we're hearing for the attorney for Carmine Fossile.
Thank you, Your Honors. So this is my name is Israel M. Sanchez, Jr., Your Honor. I'm making the argument on behalf of Carmine Fossile. To my left is co-counsel Edward Gaynor, who was counsel at the time, all relevant times that led to the summary judgment being allowed because there was no opposition. Basically, our argument is that while unfortunate that there was no opposition timely filed, but there were some reasonable considerations which I think would allow this court the flexibility to vacate that summary judgment. First and foremost, it was not of any wrongdoing or malfeasance or neglect on behalf of the client. Mr. Gaynor is here, and he can attest to the fact that he's the one that did not file a timely opposition. However, he did, at the last moment, attempt to file a notice with the court that he intended to file an opposition late.
So I do have some procedural questions, actually. First is that I didn't see a certificate of service attached to that motion he tried to file that he ended up putting the docket number for another case on it. Is there a certificate of service for that? Your opponent says no, that they were not served with it.
A certificate of service
Yes,
for the notice that he filed in the wrong court?
yes.
I don't know the answer to that, Your Honor. What I know is what I saw from the record,
Okay.
which was the actual notice which came after having a conversation with the court clerk, knowing that he was behind on the deadline to file an opposition, and the clerk suggested, did not advise, but just suggested that he do file a notice that he intended to file the motion, an opposition late. which he did.
Doesn't everything in the Superior Court have to be filed with a certificate of service?
I'm going to apologize, actually, Your Honor, for the fact that sometimes I'm not going to be able to hear everything you say because I left my hearing aids.
Sorry, I'll speak up. Doesn't everything that's filed in a case in the Superior Court, even in the wrong case, have to have a certificate of service so that the other side knows what you're doing? And where your opponent today says, we never actually got a copy of that notice, and there's no certificate in the record, can we presume that it wasn't actually served on the opposing counsel?
It certainly is my custom, and I believe
It's not just custom.
majority
it's a pretty
attorneys
basic
would
rule,
do a
right?
certificate of service. I wasn't there at the time, but I have to believe, after conversations with my co-counsel, that he was under the gun. And I think he sort of did it on the fly and probably neglected to put a certificate of service. That doesn't mean that he didn't provide something by email. I don't know the answer to that. But yes, a certificate of service should have been done, for sure.
So in this case, we have a motion to expand the record on appeal filed by your opponents. What is your position on that motion?
Of the motion itself?
Yeah.
For summary judgment?
No.
I think
They've moved to expand the record because one of your arguments is that that a binder of exhibits was not sent to the judge deciding the summary judgment motion. And they've moved to expand the record to show correspondence, a cover letter basically, which I'm not sure why they say that's not part of the record, but in any event, they've moved to expand the record to show the FedEx receipt that the binder was sent, to show the cover letter that was transmitted to the court below. And so what's your position on that motion?
I believe that this case, having started it, actually, I should say to the court, I actually commenced the action and then it took a sabbatical. And I can tell this court that this was a bloodbath of a family feud. It was very complex. There was a lot of discovery. Their brief, Your Honor, highlights what the disputed facts were.
No, I understand it was hard fought. I'm just trying to understand what record we have in front of us, and they've moved to expand the record, and I don't think you've responded to that or opposed it.
No, I did not respond to that. You're right. You're right about that, Your Honor.
All right.
So
Do you have a position now?
I'm sorry?
Do you have a position now? Should we grant that? Should we grant it in part? Should we deny it?
Given the nature of the case, I would deny it. I would request denial because this case really should be determined on the merits. I mean, that's the bottom line. That's my bottom line is simply that. This case.
Right, but one of your arguments is that a binder of exhibits was not provided to the trial court below. And and I'm asking if you're continuing to press that where they have given you evidence of a cover letter transmitting the exhibits and a FedEx receipt showing the package was sent. So on that one particular argument, are you still pressing that?
To be honest, Your Honor, I was not counsel of record, so I would not have seen it at the time. And I have to apologize for not having a good answer for you with regard to that. All I can say and repeat, I am fervent in my belief that this case should be tried on the merits. This is, even in their brief, Your Honor, at pages 17 to 21, they outline all the disputed facts that would have been raised in opposition, all of them. I mean, they say interrogatory answers were refuted by this deposition. Interrogatory answers were refuted by this deposition. Those are all issues of fact.
what we have before us is a summary judgment decision that was not opposed by your client, right? And you make a lot of arguments about excusable neglect, about your client's failure to file an opposition. But was excusable neglect actually presented to the Superior Court judge?
It was not presented before the lower court judge.
Yeah, but you seem, that's, if you want us to rule on excusable neglect, there has to have been presented, that issue presented to the judge, and she either accepted or denied it, but we can't just skip ahead where that motion wasn't even teed up for the Superior Court judge and issue a ruling on that issue if it wasn't litigated below, right?
I agree with that. I want to point out, however, that I was involved in, after the appeal was started, and raised the issue that I think you're addressing, Your Honor, by way of a motion for stay of the appeal pending so that we could file the appropriate motion with regard to excusable neglect and Mr. Gaynor's affidavit to support it in the lower court. I filed that motion with this court, and it was denied. So there wasn't that opportunity, albeit late, to bring that to the lower court's attention because I did move for a stay in order to bring it to the attention to the lower court.
But after Judge Ellis, right?
After the appeal was commenced, correct, Your Honor.
Judgment.
Mr. Gaynor.
I'm sorry, let me finish my question.
Yes,
you
I'm
didn't
sorry.
move for reconsideration, and you didn't move for to set aside the judgment, right? There was no motion practice after entry of the summary judgment against your client.
The only thing, there was no motion, that's correct. The only thing that was filed before summary judgment was allowed was the failed attempt to provide notice to the lower court of the intention to file an opposition. One other noteworthy point, Your Honor, that goes to Mr. Gaynor believing he had more time to file an opposition was that on the same date, August 22nd, I believe, Your Honor, of 2024, there was, after a telephone status conference in July 12th, I believe. After that, on August 22nd, the court sent a notice that the motion for summary judgment was going to be heard the following March 6, 2025. And even the entry of the judgment indicated that the entry of the judgment, the court held the papers for over 30 days just in case Mr. Gaynor did file an opposition late. So you had those two things happening on August 22nd as well. A notice saying that the motion was going to be heard on March 6th, and on the same date, entry of judgment.
Do you have a case that says it's okay not to file an opposition to a motion for summary judgment because an administrative order has entered scheduling a hearing on a motion?
I don't know the answer if it was an administrative error or not. What I do know from, again, my conversations with Mr. Gaynor is his understanding based on the totality of the circumstances. And yes, the judge, the lower court judge, in entering summary judgment, berated Mr. Gaynor, rightly or wrongly, for having filed things late during the course of the action.
So your opponents argue we should basically affirm using the same reasoning as a Rule 23 decision of this court, Sherwin versus the Department of Children and Families. What do you say to that?
Rule 23?
An unpublished decision. It's not a published decision, but you're saying that everything that we said there applies here and we should just follow that case.
I'm really having a hard time hearing. I apologize. I don't have my
They're
hearing.
arguing, they cited extensively an unpublished decision of
Yes,
our
Sherwin.
case.
Sherwin, yes.
Right. Why are they wrong?
I'm not sure that I would say they're wrong with regard to the argument using Sherman. What I would say is that that's not the only case law that is relevant here. We also cited a case with regard to formulating an appropriate remedy.
So what's
in the
your
event
best
of-
case?
I'm sorry.
What's your best case? And you don't need to apologize about the hearing. My hearing is allegedly normal, and I can't hear a thing. So you feel free to keep telling us if you can't hear us. We want to make sure your client gets heard. pun intended.
Thank you.
What's your best case?
Well, I think the case that we cited, Your Honor, it was a criminal case, not a civil case, but basically it stood for the proposition that when you're going to sanction, and I do believe that this judgment really, when you read the commentary by the judge with regard to the habitual lateness and holding on to the papers for 30 days to see if there would be an opposition, which wasn't done. So if you take that verbiage and the case law that we cited, although criminal, it stands for the proposition that the court has tremendous discretion to formulate a remedy if they believe a remedy is appropriate in terms of a sanction. And it just seems pretty apparent to me that the entry of summary judgment was as much a sanction as anything. It certainly was not on the merits because there was no opposition.
What is a judge supposed to do if a party files a motion for summary judgment and there's never any opposite? And what is a judge supposed to do if one party files a motion for summary judgment and it's never opposed?
Well, certainly it could have been different things. And I don't want to say that a judge did something wrong. I guess what I'm suggesting is I think there was a better way to deal with it, especially since this judge in her verbiage was critical of Mr. Gaynor's being late on other occasions. So I think one possibility would have been for a judge to issue a show cause order, to show cause why judgment should not enter or some other form of sanction. The judge could have done that, could have also just sanctioned Mr. Gaynor or the client with regard to being late. All that being said, I think the big problem...
Is it correct, though, that there's no explanation in this record when he never came forward with anything explaining why he failed to file a timely opposition or that he could have, right? Is that correct?
I don't think that I don't think that's the message that we were trying to portray here. I think the message we were trying to portray here is that he knew that he was late, and he did file this notice. It went into the wrong court. We'll never know if the lower court judge would have accepted it or not. We will never know. But given the verbiage, again, by the lower court judge, that she held on to the papers for over 30 days, almost expecting to see a motion to be allowed to file something late. So I think it's a reasonable...
All right, I think we're going to have to leave it there because your time has expired unless there are any questions.
Okay. Thank you, Your Honor.
We do understand your argument, and I assure you we've read the papers.
Thank you. Thank you for your courtesy and understanding.
Good morning, Your Honors. Robert Callahan on behalf of the appellees. May it please the Court. The Superior Court did not enter a default judgment. It did not sanction the appellant in this case. This was a full decision on the merits. As the Superior Court noted, this is entering summary judgment upon consideration of the pleadings, the lack of opposition by the plaintiff, and the appropriate legal standards.
Well, but his argument seems to be that she could have issued a show cause order saying, why are you not responding to this very significant motion?
Yes, Your Honor. We believe the central question here is whether the Superior Court abused its discretion by ruling on a motion for summary judgment after waiting 30 days or over a month after its filing, where the non-moving party did not contest any facts, filed no opposition, did not request a hearing, and neither moved to extend the opposition deadline or for leave to file an opposition late.
So I did look through the record, but I don't remember on this particular point. Was this a Rule 9A situation? Like, did you send the motion over to the other side? They didn't respond to it. You waited the right amount of time, and then you filed your papers and again sent them over?
Yes, Your Honor.
Served them?
That's correct.
Okay.
So this is ordinary Rule 9A process as modified by the Superior Court's briefing schedule. This was which set the deadline for us to serve our motion for summary judgment as May 31st, and the opposition deadline slightly enlarged to July 1st. This was actually the second time that Carmine Fossile failed to respond to our motions for summary judgment, which yielded that scheduling order that was controlling this motion process that we're discussing today.
So on your motion to expand the record, why, I'm specifically referring to the supplemental appendix 428, which is the transmittal letter to the clerk with the binder attached. Why is that not part of our record?
So, Your Honor, we've submitted a supplemental appendix, which does include the actual appendix below for the motion for summary judgment. For that aspect of our pending motion, we're seeking to enlarge
Right,
the
I know,
record
but
to include.
the order entered was that you can supplement as long as it was before the court below, and you've given us 3 exhibits that you seem to be saying were not before the court below, but one of those, I think it's Exhibit A, includes a page that is a transmittal letter to the court. So that seems like it would be part of the record.
Yes, Your Honor, and we appreciate that perspective. In filing the motion, I took a different perspective, which was what the critical fact was the FedEx submission, which also included the letter. So I don't necessarily need to parse out whether that transmittal letter, but it was really kind of the FedEx package that accompanied the binder. And again, this was only in response to the appellant's argument that he characterizes as critical in saying that this binder was not in front of the Superior Court. Our point being is that it was an appendix over 400 pages that the Superior Court considered in ruling on summary judgment. It was a fully developed record, no disputed facts, no opposition. Again, this was not a sanction.
What about his argument now that pages 17 through 21 of your brief really set out that there are disputes of fact?
Your Honor, that's a distortion of our argument. The argument below on the motion of summary judgment is that the plaintiff, Carmine Fossile, lacked competent evidence to challenge our counterclaims and to support his claims in this litigation. Again, he served interrogatories that were riddled with hearsay, secondhand stories. When I deposed those third parties that he was seeking to quote or cite, their testimony, and it's there in the appendix that was before the Superior Court, was replete with commentary about, no, I'm passing along another hearsay story. I have no personal knowledge. Or just flat out saying, I never told Carmine Fossile that. I never said those words to him. And I would ask follow-up questions. Do you have any idea where Mr. Fossile got this to put in his interrogatory responses? And responses being, I have no idea where he got that. And that's what we submitted before the Superior Court. As the court has noted, to this day, Carmine Fossile has not explained why he missed the court-ordered opposition deadline. As this court and the Supreme Judicial Court have said, it is without question that judges have the inherent authority to do what is necessary to achieve the orderly and expeditious disposition of cases, and that includes the efficient disposition of cases on its dockets. Here, the appellant failed to engage in the mandated Rule 9A process, did not comply with the court-ordered opposition deadline. He filed nothing in this case before the Superior Court until well after the entry of summary judgment, right at the end of the deadline to file a notice of appeal. What was the Superior Court to do? It had already waited over a month. It had already reset the briefing schedule deadlines when Carmine Fossile failed to oppose summary judgment the first time. And as noted by the Superior Court—
They reset the deadlines because you hadn't served it the right way, correct?
Your Honor, their claim, and again, this was another example of Carmine Fossile seeking relief late. We went through the same process again where we served our motion for summary judgment, received no opposition, held it under 9A, then filed it with the court. Time passed, and we submitted a proposed order to the court, and that's when Carmine Fossile's counsel filed the motion to strike and in the alternative to reset the briefing schedule. His claim was that we had not completed the requisite meet and confer. We disputed that immediately. That was our opposition on the record. The court nevertheless reset the briefing schedule deadlines. And again, it's within the court's, while we disagreed with that outcome, it's within the court's discretion to reset the briefing schedule deadlines under those circumstances.
So
It
there was
also
no
allowed-
finding that you didn't meet and confer, the court just gave him another chance, is that what you're saying?
Yes, there's nothing in the court's ruling saying that although it's allowing the motion to and resetting the briefing schedule, that it's adopting their characterization of the meet and confer process. It also allowed us to consolidate our motions for summary judgment. With the first round, we had served one by the initial deadline, but subsequently the court allowed joinder of the counterclaim plaintiffs, which basically served Me Too motions for summary judgment. By resetting the briefing schedule, we were allowed to consolidate into the single motion for summary judgment that the court ultimately granted.
Why was the damages hearing canceled pending appeal?
Our understanding is that because the appeal was pending, which could affect the outcome of the summary judgment entry,
Right.
that the court decided to hold off on it.
I mean, normally we see all of it at the same time. It's just curious to me why we're here on appeal when there's been no damages assessment.
Your Honor, to kind of clarify, we served, so subsequent to the entry of summary judgment, we served a motion for assessment of damages that would flow from the rulings that the court made in entering summary judgment. We served and filed that on day 31, approximately, because we had not yet received the notice of appeal. So that was pending before we knew that the entry of summary judgment was being appealed. So that had gone to the Superior Court, and I can only assume that then it was on for motion. But because there is a possibility that there could be a reversal, it could be not ripe for an assessment of damages should this court reverse the summary judgment that's been entered.
Did a judgment enter?
Summary judgment has entered.
I know,
do not
but there's
believe that
usually an order after that where judgment on the entire case issues, and because Judge Shin is right, normally we wouldn't decide a case like this.
Yeah, I don't believe that final judgment has entered yet because I think because the notice of appeal was filed.
Then do we have jurisdiction?
I've not fully considered that.
Right.
that
I mean,
question.
this is an interlocutory ruling, which we normally do not have jurisdiction over, except for certain exceptions.
Your Honor, I have not considered that question. I will say, as is probably apparent from our papers, that we have an interest in getting this matter resolved as quickly and as soon as possible without further delay.
Right, but the issue is, once there's a damages hearing and final judgment enters, there could be a second appeal. That's why normally we would have it all together in one appeal.
Understood, Your Honor. The court is correct. We believe that this case is similar to the Sherwin result, where similarly the plaintiff did not engage in the Rule 9A process, did not contest any facts. That's evidence. It's well within the discretion of the Superior Court to rule on unopposed motion for summary judgment. Carmine Fossile is now asking you to reverse based on excusable neglect. Again, he cannot raise those for the first time here on appeal. He did not express any arguments concerning any extenuating circumstances to the Superior Court. He did not. That argument is waived. But at any rate, Carmine Fossile has not identified any actual reason showing excusable neglect. He hasn't explained why he missed the court order deadline or failed to engage in the Rule 9A process. He now claims that he has been somehow confused or misled by the Superior Court clerks administratively scheduling a motion hearing. But filing an opposition past the deadline and perhaps on the eve of the hearing, which would deprive us of an opportunity to submit a reply brief, that in no way resembles Rule 9A or summary judgment practice in Massachusetts. That would undermine the orderly, predictable process by which parties to a lawsuit conduct their business. And then Carmine Fossile did nothing to act promptly and take curative action in the Superior Court. He didn't seek anything after the entry of summary judgment from the Superior Court. He never moved, he never filed that motion for an extension of time to file an opposition. He never sought reconsideration. He did not move for relief from judgment, which the Sherwin opinion tells us he should have raised those before the Superior Court in the first instance. He simply filed the notice of appeal at the deadline, and even then, he missed all of the appeals court's briefing deadlines. He did not do anything substantively in this case until the appeals court issued its notice of intent to dismiss his appeal. He points to a document titled Notice of Filing Motion to File Answer to Summary Judgment Late Together with Opposition, and that document wasn't served on us. It wasn't filed in the right case. That document should be disregarded outright. That document never matured into an actual motion on the correct docket, and it was never followed up by an opposition. The Superior Court was well within its discretion to enter summary judgment. This was a full decision on the merits. The motion was briefed, supported by appendix of over 400 pages of affidavits, transcripts, documentary evidence, and there was no disputed fact, there was no opposition, and still, the Superior Court waited over a month, just in case Carmine Fossile belatedly filed an opposition, but he never did. And so reversing now on this particular record, doing so would undermine the process laid down in Superior Court Rule 9A. It could undermine the Superior Court's inherent discretion to control its own docket. It would create uncertainty about what is a Superior Court to do when a party refuses to engage in the process, refuses to oppose a motion. So unless there are further questions, we'll rest on our papers and request that the court affirm the entry of summary judgment.
Thank you very much. The case is submitted. We understand everyone's positions. We're going to take a short recess, and we'll hear the final two cases for today. Again, good morning, and I'm still Justice Henry with pronouns she and her. This is a continuation of our sitting today, March 9, 2026, and we've got 2 cases remaining for, I'll just repeat that we have 15 minutes per side. And we'll hear our 6th and last case for today, 2025 P 523, Gerhart and another versus BURR. While we're changing over, I'll say I did enjoy the contract excerpts right in your brief. That made it easy to see what the contract said.
Thank you, Your Honor.
Why don't we wait just a minute?
Certainly.
Okay. Go ahead.
Good morning, Your Honors. Richard Pedoni with Nixon Peabody, representing the appellants Robert BURR and Hawthorne Hill. Your Honor, today I'm going to focus on 3 of the arguments raised in our brief and reply. First, the trial court made a clear error when it acknowledged that Mr. BURR's testimony that the plaintiffs affirmatively agreed with him regarding the fact that they were not entitled to any further distributions. This is in deposition testimony, and it's in Mr. BURR's summary judgment affidavit. The trial court did not acknowledge the existence of this testimony, which, on summary judgment, it was required to accept and evaluate in the light most favorable to Mr. BURR. As a result of this failure, in the mistaken conclusion that Mr. BURR only relied on 8 years of silence, the court improperly ruled against Mr. BURR on his waiver, estoppel, and laches defenses. Second, the
Counsel,
trial...
I just had a preliminary question, which was, were both plaintiffs at the same meeting at the Acapulco restaurant?
They were, Your Honor.
They were, okay. And so they each heard what the other said. Is that the idea?
I believe that's the case, Your Honor.
All right. And if I'm looking at the reply brief on page 7 with this chart, which I'll direct the other side to as well, we have Ms. Severance arguing that, or stating she recalled the conversation, but there doesn't seem to be an acknowledgement of agreement, but that Mr. Gerhard says he did object to this. But he does seem to acknowledge BURR saying that he would not continue to pay. Is that what you're relying on?
Your Honor, I'm relying specifically on Mr. BURR's testimony, which is what must be accepted for purposes of summary judgment, and Mr. BURR's affidavit, which was part of the summary judgment record. I'm not relying so much on what the plaintiff said in response, because we must take Mr. BURR's statements of what occurred as the facts for summary judgment. Did that address the court's question?
Yes.
And Mr. Burr's statement was essentially, well, the plaintiffs confirmed that their end of the employment also meant end of participation distributions. And then he was asked, what do you mean by confirm this understanding? And he said, it would have gone something like, we're going to have to go find another job because we're not going to get any more participation agreements because College Street is no longer our employer. That's the testimony that you're relying on for these arguments, right?
Your Honor, that's a piece of it. The summary judgment affidavit in the appendix, volume 2, page 64, Mr. BURR states, at the lunch, Gerhart and Severance acknowledged that they would no longer receive distributions under the participation agreements because they were no longer working for College Street. And then in Mr. BURR's deposition testimony, which was part of the summary judgment.
That's a conclusion. That's his conclusion about what they said. But his only testimony as to what they actually said was, it would have gone something like, we're going to have to go find another job.
That's correct, Your Honor.
Okay. not a very strong statement. I mean, you're relying on this statement as the basis for both an estoppel and a waiver claim. I'm not sure it gets you to either of those, but go ahead.
I believe on summary judgment, for purposes of viewing that in light of the most favorable to Mr. Burr, it's actually an extraordinarily strong statement. But most importantly, for these purposes, it's a statement that the trial court made its decision as if that statement didn't exist.
Well, yeah, but we're doing summary judgment de novo. So
Yes.
tell me how that statement amounts to a statement intended to induce reliance by Mr. Burr. A statement that, yeah, we're going to have to go find another job. How is that meant to induce reasonable reliance on Mr. Burr when Mr. Burr could just go and read the contract, which the judge found unambiguously provided that these rights continued after their termination of employment?
So, Your Honor, first I'd begin by noting that the judge also found that the contract was difficult to parse.
Okay.
And that's a
But he said it was, the fact that it's difficult to parse doesn't mean it's not unambiguous, right?
We're not raising that issue on
Okay,
appeal, but it
okay.
is definitely difficult to parse. And so Mr. Burr's reliance, his perception, his understanding of the contract, which were laid out in where I'd go for the reliance, it'll take me a minute to work through this. With regard to the reliance and the context of which Mr. Burr received those statements, it was his uncontroverted 100% belief that at the end of employment, the participation agreements came to an end, the participation payments came to an end. And you would then say—
Can that actually be the basis for reasonable reliance if there is a document, a legal document, that sets forth the actual rights provided under the contract unambiguously, albeit in complicated language? Can you actually have reasonable reliance on what someone else tells you about maybe their perceptions of the document? Isn't that a problem for you, that you actually have a document, a contract that kind of lays out the rights, and we're presumed that the parties to the contract read the document and understand it?
So, Your Honor, we have three pieces of evidence concerning what the actions and statements that were made in reliance. There's an additional statement in Mr. Burr's deposition. They both confirmed all of our understandings that at the end of the employment, that also meant the end of the participation agreements. We then have 8 years of complete silence from the plaintiffs. So our biggest concern with error is that the trial court did not acknowledge all of the statements that were relied on, because, of course, whether the reliance is reasonable in part depends upon what you're relying on. And here we have multiple statements over a period of time. This was laid out in the statement of facts in opposition to the plaintiff's motion for summary judgment, which the trial court did not seem to focus on. So we have these statements, and now going directly to your point, which is it reasonable to rely on these statements or any statement when the contract says something? Well, then you need to do what the trial court did not do, which is look at the circumstances in which the statements were made and the circumstances of the reliance. Here we have a contract that is difficult to parse. The court took pains to note that. And then we have Mr. Burr's uncontroverted understanding that the payments came to an end. Why did they come to an end? Well, you would go back and you would say, what was the understanding when the parties entered the contract? What was Mr. Burr thinking when these statements? What were the plaintiffs thinking when they made these statements? And they were all thinking, we submit on summary judgment, taking the evidence in support of Mr. Burr, they were all thinking that, in fact, the payments came to an end, because that is what Mr. Burr intended for the contract to read. That's evidenced by—
The
Yes.
plaintiffs argue that if their rights under the contract extinguished upon the termination of their employment, there would have been nothing for your client to buy back. Like, the buyback provision basically would have been a nullity. So what do you say to that?
Your Honor, I'm talking not so much about revisiting the issue of whether the contract's ambiguous. I'm talking about Mr. Burr's understanding of the contracts and the plaintiff's understanding of the contracts at the time that those statements were made, issues that the trial court never got to, and that if you read all of the summary judgment depositions, you realize these parties may not have had the perfectly clear view collectively of what the contract said, but the conduct were very clear statements that Mr. Burr heard that he reasonably relied upon to not exercise the purchase option, as well as 8 years of silence. It's extraordinary. They continue to have interaction.
Your argument is that he put in enough evidence to say they agreed with him that the payment stopped, that meant we couldn't have a summary judgment on liability. Is that right?
That is correct, Your Honor, as well as the reliance rolled over to damages because of Mr. Burr's conduct that they knew he would be undertaking.
Well, assume for a minute that he and the plaintiffs spoke after the contract was signed and plaintiffs agreed to give up their rights under the contract. What consideration would the plaintiffs have been offering?
Your Honor, that would be going to the waiver argument, whether there was a knowing and intentional relinquishment of their right. So if the plaintiffs intended to give up the right, then we have statements to that effect in waiver, and I don't believe consideration is necessarily required in the context of waiver. Mr. Burr relied upon those statements.
So on waiver, you need an intentional relinquishment of a known right.
That's right.
And your argument is that the statement in Acapulco's, according to Mr. Burr, well, I guess we're going to have to find another job, that amounted to an intentional relinquishment of the rights they had under the participation agreements?
No, Your Honor, that's not the sum of the statements in the context of the conversations at Acapulco was, we're going to have to find another job. That is one indicia of the reasonableness in everyone's understanding. A fact that occurred was they made that specific comment. But it was in the context of agreeing with Mr. Burr that they had no further rights going forward. In the summary judgment record, and again, I'd refer the court back to the statement of material facts in the opposition. It lays out for 3 pages facts around those circumstances the court simply never got to. And if this court were de novo to decide to make a decision on reliance instead of referring it back to the trier of fact, and again, the trier of fact did not, the court on summary judgment did not get to the reliance issue. If you go back to the facts that are outlined there and what are in the deposition, transcripts that were part of the summary judgment record and Mr. Burr's affidavit, then the reliance actually makes sense, in particular because this was entered into in the context of an employment agreement.
So you say that there was an agreement at the restaurant?
They agreed with him that they were no longer entitled to any payments.
And that was an agreement that overrode the terms of the actual written contracts?
I'm not arguing that they altered the contract, Your Honor, although they could have.
Well, I don't understand. What do you mean by agreement?
Do
you mean like a binding contract was reached at the restaurant?
No, Your Honor, that is not our argument. What our argument is that the circumstances amount to estoppel. They made statements that they knew he would reasonably rely on, that he did reasonably rely on, that altered his course of conduct. So when a party makes a statement concerning any fact and it's reasonably relied on, and Mr. Burr did not exercise an $11,000 per individual payout purchase option, he testified, and we have a proffer that is part of the record in Volume 3.
Why would the plaintiffs in that situation want to have to induce Mr. Burr's reliance on these statements? Because is your theory that they didn't want him to exercise his purchase rights within the year, and therefore they were kind of lulling him into thinking that they didn't think the contract extended beyond their employment, and therefore don't exercise the purchase rights, and then 10 years down the road they'd come back and enforce those rights? Is that the theory?
Your Honor, malicious intent and wrongful action are not part of what goes to estoppel.
But reasonably intended to induce reliance is part of the claim. So I just don't understand that. But what were they trying to induce from Mr. Burr? What kind of reliance?
We should look at the circumstances in which they made those statements, which is Mr. Burr would have had the option, had they had a disagreement with him, and to exercise that purchase. He says in his proffer, I would have gone, and we tried getting into trial at testimony, tried getting testimony in at the damages trial. I would have gone and gotten counsel if I had known there was a disagreement and they had not agreed with me. They didn't have to agree, and they didn't have to stay silent. They're both sophisticated real estate professionals. So Ms. Severance did all of the calculations of these numbers and the amounts while she was employed by Mr. Burr at College Street. And Mr. Gerhart was a sophisticated real estate professional. And they made the statements, and they should have known that he was going to rely upon them. And he did. And if they made the statements with a full intent to give up the right, well, then that's a clear waiver. And these are issues that should be for the trial of fact. And Mr. Burr's statements of, they definitely agreed. I mean, he's testifying in his affidavit that they actually agreed with him. It's not, you're not required on summary judgment, give me every word that the other party said. That's an issue for trial. And he wasn't asked those questions at his deposition.
Well, we can assess the evidence of what they said. I don't think we necessarily assess what Mr. BURR thought they meant by it, right? That's a legal conclusion to sort of say, wow, he thought they agreed to this. What matters is what he testified they said, and what he testified they said was, it would have gone something like, we're going to have to go find another job because we're not going to get any more participation agreements because College Street is no longer our employer. That's the extent, as far as I can tell from the record, of what Mr. BURR said the plaintiff said at the restaurant.
Your Honor, this is not a trial record. Mr. BURR is entitled to have a trial and testify. He's entitled to have his wife testify.
Well, they seem to argue that we shouldn't consider the wife's testimony because it was submitted very late. What do you say to that?
Your Honor, on the motion for reevaluation was two parts. One, we asked the court to look at the summary judgment evidence that it didn't look at and acknowledge even existed. And two, the wife's testimony. It was a two-part motion, and I certainly understand the timeliness of the errata sheet not coming in. Your Honor, I'd like to turn to my statute of limitations argument, and I appreciate the court recognizing that we specifically noted the signature blocks, because I do believe that is what the court needs to focus on in the not decision, and we laid out in our brief. The plaintiffs need to establish that they're entitled to the relief available for the 20-year statute of limitation by proving their case. And the seal replaces a signature. And we have two signatures, or preceded, and we have two signatures. And only one of the signatures here has the seal, and so it's as if that second signature doesn't exist in the contract.
Right, but
and
the
was
signature
required.
that had the seal, isn't that your client's signature?
No, Your Honor. If you look at the contract, those are illustrative. There are 4 contracts. If you look at the 4 contracts, they called for 2 full signature pages. 1 on the master document and 2 on the document that identifies the transaction at issue. When you look at the second document called a schedule that identifies the transaction at issue, it doesn't just call for initials, it calls for a full signature.
Right, but I'm looking, for example, at the excerpt of the contract on page 13 of your brief, and the statement executed under seal is immediately above Mr. BURR's signature, right?
Yes, and then it's above both signatures, both
Right.
party signatures, and then if you look at the second required signature for the document, there is no seal reference on it.
You're talking about Gerhardt's signature.
Now, Your Honor, if the court were to look at the actual participation agreements,
Talking about the schedule and the next.
Got it.
which are in the
Are you
revised-
talking about Schedule A?
yes,
Okay.
which has a full required signature block for both parties, and there is no reference to seal on that second
Okay.
signature block.
All right, I think
Thank
that your time has expired, so I just want to see if my colleagues have any questions.
Can I just ask,
Yeah, oh,
do you have any case that says you have to have the words under seal repeated every time there's a signature or initials on a contract? Because Schedule A is incorporated, is part of the overall contract, under seal appears before the main signature block. It seems a very novel argument to sort of say, well, there's another signature in this document, the words under seal aren't there. Why wouldn't we sort of read the contract as a whole and say that, under the statute, the fact that it says under seal above the main signature block gives it the effect of a sealed agreement under Chapter 4, 9A?
Right. So there is no integration clause bringing Schedule A into the main contract, which many agreements have, schedule incorporated herein. There is no case. This is actually an issue of first impression, Your Honor. I can't find a case where parties have litigated whether there needs to be a full recital in the recital section, with the parties elected to have here a recital section, and that's our argument we laid out. But certainly if you look at the policy of a seal, the signature with the words replaces the seal. And in the history of the statute and what the statute replaced, which was people putting wax, without the word seal, you actually don't have a full binding agreement. And it's a material list of integral terms, such as the project to which it applies. Thank you.
You're good?
Yeah, good, thanks.
Thank
All
you,
right,
Your
thank you. We'll hear for the attorney for the plaintiff appellees.
I think we're to the afternoon hour, so good afternoon. David Rich on behalf of Mr. Gerhardt and Ms. Severance. The first point on this estoppel argument I want to start with is what isn't before the court on appeal, which is the enforceability of the contract and that it extends beyond their employment. Why is that important? Why is that material here? Why am I wasting your time talking about things that aren't before you? Well, the entire premise of Mr. Burr's estoppel argument is based upon my client's alleged response to Mr. Burr's statement, which reflects, now we know, a misstatement of the rights and responsibilities of the parties. Why is that important? The doctrine of equitable estoppel is a defensive doctrine. It's designed to prevent wrongdoing, like in the Renovator Supply and Sovereign Bank case, which from this court, in which the doctrine was invoked at the same time the bank was adjudicated to have violated 93A, because what they were doing was extending these lines of credit after the technical time by which the term ended, and then all of a sudden, after the term ended, they flew in there and said, oh, if you want to extend this time, you're going to have to pay us additional interest. So there's no evidence, and there was no evidence of wrongdoing whatsoever by
But if we just look at page 7 of the reply brief, and I think it's in his opening brief too, he is offering testimony that they both said they understood, rightly or wrongly, that they were not going to get any further payments under the distribution, the participation agreement. I mean, do you agree he asserted that below? I know you don't agree with the substance, but...
Yeah, yes, but I focus on what Judge Toone said, which is the response. The response wasn't, as he testified to in his deposition, I agree with you, we will forever surrender our rights to seek relief under this. It was, we're going to have to go find another job because we're not going to get any more payments because College Street was no longer their employer. That was true. Whether it was intentional or unintentional, they weren't getting more money unless they went and filed a lawsuit. And that's why, and I want to draw your attention to a case that isn't cited in our brief, but I do think it's worth focusing on. The Nahant case, 104, Mass App Court, 698, 714 at footnote 19. And what footnote 19 says, citing an SJC case and another appeals court case, is, quote, the equitable estoppel doctrine doesn't apply and only will apply when a party is induced to act in reliance on a representation of past or present fact and not a promise of future conduct. So even had my client said, we agree, we'll not pursue this in the future, the doctrine of equitable estoppel doesn't even apply. As a matter of law, it doesn't apply.
Just take for a moment, let's assume your clients won, the lottery, and they were sharing a $50 million jackpot, and they said to Mr. Burr, you don't have to make any more payments, we got plenty of money with our $50 million, and Burr said, thank you. Could they do that orally on a handshake and be bound by that?
Not in this context, I don't think so, because there'd be no consideration, as Your Honor pointed out, for that promise. And the notion that that would be a promise of future conduct, which the Nahant case, which cites those two cases, says isn't the case. Now, I would admittedly, it's a closer call than this, but one cannot surrender one's rights by promising future conduct without a modification to an agreement which is supported by consideration. And again, context here, to the extent you ever need to get here, I don't think you do matter. These were employees that were going to a lunch having been terminated. They don't like to use the word fired. I don't know what word they'd like to use. And their boss telling them, I'm not going to pay you anymore. And the notion that under those circumstances, one, in the context of that discussion, forever forgoes their rights to seek legal relief, where Mr. Burr can take, I think, $16 million out of the business in the succeeding years and have no obligation for a contract which the Superior Court determined as a matter of law entitled my client to this benefit and is not part of this appeal.
Do you agree that under the contract he did have a year to buy them out?
Yes, he did.
And for a fairly nominal amount of money?
I think that there was never a fully fleshed out, certainly more than the amount that he ultimately the court ordered him to pay, certainly. But my response
He
to
could have bought them out for a lot less than what the court.
Agreed. He could have
Okay,
bought them out
and
for a lot.
But his argument is, so when they stay silent in the face of this statement of his, which Gerhardt seems to acknowledge, that there has to be some consequence to that.
Well, Gerhardt doesn't acknowledge that. That's where there's a dispute in the fact. Gerhardt says that he did respond.
Do you,
But
I want to know if there's any mistake on this testimony on page 6 and 7 of the reply brief, because this has Gerhardt as saying BURR said he would not continue to pay.
I think what Gerhardt's testimony is quoted, and he disagrees aggressively. I think Ms. Severin, the testimony was, is she didn't remember. I think
Hers
Judge
is
Toone-
more equivocal, but he says, he admits BURR said he wouldn't continue to pay.
And he disagreed with him.
Right, but that, in terms of the equities and whether or not, so then BURR doesn't know he disagrees. I mean, your client says he did object. And so then BURR doesn't use this off-ramp of the contract that's fairly inexpensive.
Well, Your Honor, Judge Toone asked a question earlier about legal authority for the notion, and I understand I'm sort of jumping around a bit, about whether reliance under those circumstances can be reasonable in the face of a written contract. And the Massengill versus EMC case from this court says it's unreasonable as a matter of law to rely on an oral representation which specifically contradicted by a written contract.
What case are you relying on for that? What case are you citing?
I'm citing it's in our brief, the Massengill case versus EMC. We also cite in our brief the Harrington versus Fall River Housing Authority case, which is in our brief, and the Morton Street Sheriff for Suffolk County. I think that's a Judge Gantz decision that went up to the SJC. Now, admittedly, those two last cases had the overlay of a municipality being involved and how the court doesn't like to invoke in those contexts. But clearly, I think in the Harrington case, the Housing Authority made affirmative misrepresentations, and the court said, we're not going to invoke the doctrine of equitable estoppel where there's a written document that directly contradicts that. And so
Now, that argument may work for estoppel, doesn't necessarily work for the waiver argument, 'cause you can waive rights that are clearly
yes, and when you get into the waiver argument, I think, and Judge Salinger got it right, quoting from Williston, you need clear, decisive, unequivocal conduct indicating that the counterparty would not insist on adherence to the provision. It's uncompromising. That's what the cases say. Here, you have someone at a lunch where they're getting fired, not, I think we say this in our brief, violently flailing about and yelling and screaming that I don't agree with you, I don't agree with you, I don't agree with you, I'm going to sue you. This is not waiver, and there isn't a single case that the appeals court or the SJC has said where there's similar circumstances. It also dovetails right into this idea about this concept of silence, which there was no duty to disclose here.
When does this agreement terminate?
The agreement terminates upon there being a capital transaction, meaning the underlying asset is sold.
It does not terminate until the happening of an event.
Correct. There were two real estate properties. One of them, the Commonwealth Ave, was actually sold, and and then there's the second one, which still continues.
They're entitled to distributions until that property is sold.
Profit distributions.
Right.
So it's not the only, and again, it's not subject to this appeal, but what Judge Salinger found was every time Mr. BURR took $1 of profit from this, they got their 10 cents. And so it's not, and it is effectively, Your Honor, like phantom equity. So, Your Honor, I've sort of bounced around a lot here, and I think I've touched on this. Unless there are more questions on the equitable estoppel waiver and latches, I will move on. With the exception, I did want to point out, because Your Honor had asked the question about Mrs. BURR's testimony, and I think you've got it exactly right. What happened is that the summary judgment record did not include Ms. Burr's testimony. We go to trial. Judge Salinger rules at the trial, and they then file a motion seeking to insert her errata sheet into the summary judgment record. So the standard of review there isn't what she said and a de novo review. It's, did Judge Salinger abuse his discretion by not considering this in the context of a motion for reconsideration? And a motion for reconsideration is very, we all know what the limitations are in a reconsideration motion. So really what we're looking at is Mr. Burr's testimony, which I think Justice Toone has clearly, squarely identified the contours of what we're looking at, and is that enough? Very briefly, moving on to the seal. It's a very novel argument that every time someone signs a document, whether it's 12 times, 15 times, you have to set forth the recital. There's no case in jurisprudence that says such a thing. There's no case in jurisprudence that says that it has to be in the section entitled recital with the capital R.
Is that a term of art, that word recital? Or
Well,
does it mean just to recite?
Correct. In the statute, I agree with you. It can be anywhere, and there's case after case after case after case, City of Boston versus Roxbury, where it just has to be in the document to recite, set forth.
There's no case that deals with two separate signature blocks, correct?
No, but here
what do we do
it
with
is
that?
one agreement. And Judge Salinger correctly said Schedule A is part of the participation agreement. It is not a separate contract or instrument. If you had, similar documents and one said it and one didn't. But here, there is no suggestion, certainly not in the statute and certainly not in the case law, that says that every time a signature exists.
Case law doesn't say one way or another, right? So do you think the SJC's pronouncements that this statute is kind of a relic and it should be construed narrowly works in your opponent's favor?
Well, no, not in this context. And the reason why is because the statute uses the word instrument. So it talks about the instrument in its totality. And it's in the instrument requires a recital, period. It doesn't say anything that would suggest that within the same instrument there are requirements that.
What if there is an amendment?
If there was a separately executed amendment, it would depend on what the amendment said, but I would say that becomes much closer to a situation where the freestanding, standalone instrument must recite whether it's under seal or not. But I think it would depend in part on what the amendment says. Does the amendment say, for example, we incorporate herein by reference all of the preceding, but I agree with you, Justice Shin, that would come closer to being something where one could argue it's a separate instrument, it requires a separate sealing, so forth and so on. But this is a singular instrument, and that's what the statute speaks to. There are a bunch of other arguments we make in our brief.
Could I ask you a question about damages?
I would.
So if BURR historically has charged a management fee
Yep.
anytime he made the distributions, why wouldn't that be relevant to damages?
So what Judge Salinger found was that he didn't charge a management fee. And the books and records upon which he presented and paid taxes.
When the plaintiffs were still employed.
He did, and then he
Okay.
stopped doing it.
Right, because he wasn't paying them anything. But if historically he charged it, why isn't that relevant to damages?
Because he made a decision, a tactical decision, and it has to do with the manner in which distributions are taxed and management fees are taxed. And he made a tactical, knowing decision with his tax preparer that he would characterize the money that he was taking out of the company as a distribution. He made that representation on his books and records. He made that decision to the Internal Revenue Service and the Mass Department of Revenue, and he received a significant financial benefit based on that tactical decision. And what Judge Salinger said in a manner that was consistent, and he did not abuse his discretion, is, I'm not going to let a litigant, in the context of a lawsuit, go back and recast their books and records in order to make a litigation argument. We're going with what you represented to the world and to the government when you paid taxes on these particular items, and we're not going to
Is
let
the idea that on the management fee, he would be paying income tax, and on the distribution, he's paying capital gains?
Exactly. That's exactly it.
All right, your time has expired. I think that it's well argued and well briefed, and we understand your arguments. The case is submitted. That concludes our sitting for today for this panel, and I want to thank all of our court officers and staff for the work that they did so that we could have this sitting.
And sorry for prematurely jumping on the argument.
It's okay. It's sometimes that happens, so.